Representative Wu.
Thank you, Chairman. And help me try to kind of fully understand this, sum up, and says this is the way I understand it. The existing law that's on the books has, over the past decades, through tens of thousands of cases in the appellate courts and whatever, have been hammered, have been mashed, and sort of like evolved into the system where everyone, it's not perfect, but everyone kind of knows what it is and what it means, and that if we try to pass something to define it exactly, it'll overturn all that, it'll overturn the apple cart. And it'll actually potentially make things worse for families, because now, if we encoded the Hawley decision, right, and put it in the law, that actually potentially could redefine what those words means, because then we are adding in legislative history into those terms, and then when people fight over exact definitions, and people say, well, it doesn't mean what the court meant back then, because now you've had this separate debate in the legislature over what this term means, and I think this new interpretation should hold over the old interpretation, right? And it could cause more problems.
I think you're right. It could cause more problems, and it could be challenging. And again, I don't know that the judges are going to be better because of it.
Right.
And we're courts of equity. Family courts in Texas are courts of equity. We're supposed to do what's fair and equitable. Right. And so hopefully legislation would be guiding and helpful in that and not make it more challenging.
And I think there's I'm not sure if you see it the same way, but I think there's a big difference between the legislature telling the courts and juries what is best interest versus the legislature telling them, well, these things are not to be considered in best interest. Say, like, if one parent has more money than the other parent, we say you may not consider this, versus us over here telling us you must consider these factors, because that could mean that you don't consider other factors. But we are saying over here, as a public policy issue, we don't want you to discuss which parent can buy the bigger car for the kid. That's absolutely prohibited. Are those things the same or different?
I think it's very different. Saying you can't consider, for instance, you can't consider the religion of the parents, versus you must consider these 4 things, or these 3 things, or these 7 things, some of which may or may not be relevant with regard to the particular child in front of you.
So that being said, if the legislature wanted to do something in this arena, maybe a discussion about maybe we should prohibit certain types of considerations, such as religious considerations, right, or money factors, or different things, or we have a prohibition that says you may not discuss that a mother is better than a father at parenting, right? If that's brought up, that's an immediate stop to the trial, and then you're going to have to address the jury and give an admonishment to the jury. Right?
And some of the examples that you give, like the tender years doctrine, has been basically done away with by case law.
Right.
And so, and it doesn't require statute to say, oh, by the way.
Right, and potentially, if we pass new statute, that new statute could be seen as overriding existing case law that would govern it.
I think that's true, and part of my concern is it would also be seen as limiting you.
Yes, thank you.
Which is a bigger concern.